Expert witnesses for different parties often have to meet and try to narrow down the issues between them. But what happens if personal differences prevent them doing this? Welcome to Expert Witness Red Flags. My name's Mark Tottenham. I'm the author of The Reliable Expert Witness, a handbook for expert and professional witnesses giving evidence in courts, arbitrations and other tribunals. Now, it's a long-standing rule in most common law courts that experts should assist the court in narrowing down the differences between them. This requires the parties to identify the issues and the experts to make sure that, having considered the primary material and applying their own specialist knowledge, that they identify any key differences between them and the experts on the other side. But if the experts fail to meet because of personal differences, they are breaching their obligations to the court. And this is what happened in the case of Trebor Bassett Holdings Ltd. And ADT Fire and Security plc, which was heard by the English High Court. Now, the case concerned a fire in a confectionery factory, which had broken out in the area where popcorn was being cooked in hot oil. A small fire broke out, and they thought that they had extinguished it, but it later transpired that it had not been properly put out. It spread and ended up destroying the entire factory. Now, in a case like this, it can be very difficult to establish who was responsible for the outbreak or spread of fire, because the destruction of the building necessarily involves the destruction of a lot of the necessary evidence. So it's a very technical issue for the fire experts to go through and find any necessary evidence. In this case, there was a direction of the court, first of all, that the parties identify the issues between them, and then that the experts meet and provide a joint report. The parties failed to comply with their obligation to identify the issues, and the experts failed to meet. When the court asked why the experts had failed to meet, the judge was told that the experts had fallen out. So what did he say in response to this? Bluntly, I have to say that experts appointed in civil litigation have no business to fall out and to fail to comply with the orders of the court. Experts are there to provide evidence on technical matters in order to assist the court and for no other purpose. If they take matters of personal disagreement to such a level, they are failing to provide that service. Ultimately, the judge found that the owners bore a large responsibility for the spread of the fire and apportioned liability against them at 75%. But the lesson for expert witnesses is clear. If you accept instructions in a high-stakes case and the court gives an order that you meet the other experts to narrow down the issues between them, you must comply with that order and don't let any personal feelings get in the way. And if you want further guidance as to the work of an expert witness, have a look at my book, The Reliable Expert Witness, or see my website, marktottenham.com.